Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu.
Kenyans will be shocked.
Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures in support of this motion.
It is 6 a.m. in Nairobi, Kenya on this Thursday, the 17th of October, 2024. Good morning and welcome to NTV's coverage of the impeachment trial against Deputy President Rigathi Gachagua as the nation stands on the brink of a historic moment in Kenya's political landscape. Now, today marks day 2 of the impeachment trial, where the stakes are unprecedentedly high. After a gripping marathon session that kept senators debating until 11 p.m. last night, the country braces for what promises to be another intense day of deliberation ahead of tonight's make-or-break Senate vote on the impeachment, which could decide the fate of Deputy President Rigathi Gachagua. With every argument, testimony and counterpoint, the very future of Kenya's governance hangs in the balance. Will the trial set a precedent that resonates across the political landscape, or will Gachagua's defense be strong enough to sway the Senate? Stay with us as we unpack the key moments from day 1, the fiery exchanges, the legal strategies, and anticipate the high-stakes decisions that could unfold today. Do join the conversation on our social media channels at NTV Kenya as we unpack this debate. We'll be sampling your thoughts, your comments, your questions with an able panel of guests in studio to put it all into context for you. And joining us this morning is governance analyst Charles Munyui. Charles, a very good morning and thank you for joining us on NTV today.
Thank you very much. I do appreciate being here. It's been a while.
Thank you. So it's a great day. I mean, however things go, history is likely to be made today in one way or the other. But even as we anticipate the Senate to sit on the second day of the trial at exactly 9 a.m. this morning, after almost burning the midnight oil pretty much, what stood out for you on day 1 of the ouster trial?
I think, first and foremost, I think in this country, people have been denied civic education. They don't seem to understand how these things work, to the extent that when public participation happened last week, there was a lot of stuff going on. People assumed this was a ballot, it was like a recall election, to the extent that some people were tearing ballots, others were doing all manner of things. Many did not take advantage of the online platform to translate, to share their thoughts. I think that is what is playing out, because up to today, many have not appreciated that what happened in the National Assembly in terms of filing or the motion or notice of motion, having the motion presented to the National Assembly, and the National Assembly basically voting for the whole motion. Now, the second phase of this is now the trial. So the Senate is basically a trial court. And that's why this is happening. That's why the excitement is around the Senate, because people did not see this happening in the National Assembly. I think many assume that the exact same thing that's going to happen in the National Assembly is the same thing that's going to happen in the Senate. So no wonder people are wondering, hey, who has lost, who has won, what is going on? Are these, what are the accusations, and has someone won? What's going on? So I think it's good to appreciate that the 11 counts, first and foremost. Yesterday, the case was being put to the Deputy President. Today, he will have an opportunity to also bring out evidence and testify in terms of, basically say his side of the story. There will again be cross-examination, examining what he's saying. But at the end of the day, it's good to appreciate that it's Mutuse's case to prove. And I think that's what is going to keep playing out. Later today, we are basically going to find out a lot of things, including what the Deputy President has to say about the 11 counts, the allegations against him. Importantly, 2 things. Number 1, just 1 count is sufficient to convict him. Right. And number 2, much as the burden of proof is on the side of the people who have the case, which is the National Assembly, courtesy of Mutuse, the standard of proof is reasonably low in terms of how much do you need to prove of any one of these counts. And I think that's why the Deputy President's team is working very hard to disapprove just about everything. So some of these things are going to play out. And remember, ultimately, it is for the senators to vote based on their conscience. And so it's more of a political process than a legal process.
And you raise very key issues. So let's begin with what you just said, that the standard of proof is pretty low as to perhaps the thresholds,
Yes.
within which you have to, produce evidence and deduce evidence. So what do you make then of the defense that has been put up on the first day by the Deputy President's team?
It looks good, prima facie. Just looking at it, it didn't look bad at all. But again, remember, there are quite a number of counts in there. And the reason as to why usually the person bringing in these cases wants to spread it all the way is because out of those, one is sufficient to convict. Just one of them. It might be the smallest in terms of the minds of the average person, but that one convicts you, and that's the end of that. That is number one. Number two, again, like I said, unlike a criminal matter where you must prove things beyond reasonable doubt, or civil, which is slightly lower there, which is on the standard of proof is basically the balance of probability. Issues of the impeachment fall in between. Yeah, so that's why it is better to go out all the way with everything that you have and fight it out with everything you have. Otherwise, you might assume those bringing out the case against you must prove beyond reasonable doubt. Kumbe, all you need is to just slightly go above the balance of probability.
And we'll get to the prosecution, but I focus on the defense because we also saw them, later in the night sort of deconstructing the evidence that had been produced by the prosecution,
Yes.
Going video by video, asking what really was wrong with the words of the Deputy President here. Interesting that in many of the counts, the issue was the words of the Deputy President, what he said.
Yes.
And many have said he has a very sharp tongue. But we had the mover of the motion, MP Mange Mutuse, really, get a draft in that cross-examination.
Yes.
And we saw the senators later on, coming to question whether he really was part of the drafting of this motion, because he didn't seem quite, conversant with many of the things during the cross-examination. What did you make of his cross-examination, his demeanor, really, and everything that came out during that bit of the trial?
I think he found himself on a side that he does not usually find himself on, like having to respond. When you're the accuser and you're used to accusing, you're used to standing in parliament and saying your stuff, and then all of a sudden you have to find yourself on the other side, having to give information. It can be tricky, much as you're with your peers. But I think it is good to appreciate that all these counts must fall within three categories. Yeah, it is about breach of the gross violation of the Constitution. It is about committing a crime, both based on international or local Kenyan law. It's about gross misconduct. It must fall within that three categories. So, much as there are 11 counts, it is good to appreciate that all the Mutuse wanted to prove is that some of these things are falling within that. Now, having said that, if you look at the side of the defense, what they were doing is what is expected of them. That is exactly what a defense is supposed to do. It's supposed to deconstruct all the evidence you have. It's supposed to deconstruct all the allegations you have. So essentially, that is what is supposed to happen. Like I said, remember, and ultimately, it's about the senators. It's about convincing the senators. And the senators, with a lot of respect, are also politicians. So that at this level, that's where we are.
All right. And I've seen many comments on social media. We'll be sampling them a bit later. Yeah. But many, of course, cheering each side of the trial, but some saying, to the defense, don't celebrate yet. This is not a house of integrity. So we'll be debating that and what Kenyans really expect after the entire Senate debacle. So let's bring in now lawyer Areba Samba as well as political analyst Peter Muchendu. Gentlemen, very good morning and thank you for joining us here on NTV. It's an interesting morning. It's been an interesting evening last evening as the country was treated to what many say was perhaps a better spin of legal shows like Suits, you know, so it was very interesting. Araba, let's begin with you, because a lot played out, you know, a lot of legal jargon, a lot of, I mean, it was an interesting episode. What did you make of the case put up by the prosecution and the defense put up by Gachagua's team?
I think the excitement that was being elicited, let me say it's some false kind of excitement, because in a system like ours, where then you have to put your case and you have to be cross-examined on it, then there are so many things that get to come. And this is what we get to see every day. Remember that the only other time that we have experienced such high level of, let me say, legal brilliance, in quotes, is during probably the past presidential petitions. And then we had the case on the BBI. I think this is the only time that, these are the times that we have gotten to see legal brains coming out and prosecuting and defending their matters. I think previously Kenyans have only been able to watch this on TV, and that is why they are appreciating that, hey, you know what, this can happen in our jurisdiction. And as I've commented before, in that this exercise is not only very important for the country, but also it's very important for, let me say, law practitioners, law students, and scholars. Because at the end of the day, once the decision is made, we have other things that we are going to learn in terms of then how not to impeach a deputy president, or how to impeach a deputy president, or how to impeach a governor, or how to impeach a deputy governor. So it's quite, remember that we are just a couple of years into our constitution, and these issues of impeachment really came into the same constitution. So it's quite an interesting point, and that is where you had in the opening remarks of Senior Counsel Honorable James Orengo, saying that it's a monumental moment, in that at the end of the day, once the decision is made, the decision will be more like a sideshow, but then the process and even the ensuing legal battles, one thing I can promise you is that the legal battles are not yet over. Remember that the day of yesterday, the 3-judge bench did indicate that, hey, you know what, you guys go, play in the Senate. Depending on, it doesn't matter how the decision goes, then come back. The court will have an opportunity to make recommendations on how not to and how to in the future. So for me, it's a bit quite an interesting time. But remember, today again, the defense will take its the stand, and it will equally be cross-examined. So the play that we had last night, where people are being told that, remember, even if it's getting hot, relax, we are likely to see again that today. So, I mean, the balance will tilt today, in that where now it shifts to the deputy president now being cross-examined on his evidence.
All right. And it's expected to be quite a showdown as senators begin then by asking questions to both witnesses. Of course, that was pending business from last night. Let's bring in political analyst Peter Mshendu. Peter, very good morning, and thank you for joining us on NTV this morning. Let's begin with what stood out most for you during yesterday's entire trial, and what your expectations are today.
You know, I have to give it to the lawyer of the deputy president. He has really earned his money, because the reason he is there, it is actually, as Charles has said, is to deconstruct the case of those who have accused the deputy president. But nonetheless, you realize that when you are doing cross-examination, I'm not a lawyer myself, but like my two panelists here, but when you're doing cross-examination, you are supposed to start from where you think the case is weak. And you realize that that particular attorney did not dwell too much on so many of the 11 charges. They are trying to deconstruct one charge after another. But it is good to let Kenyans know that the only thing Mutuse needs to do is sustain just one charge. It is enough to impeach the deputy president. Right. And therefore, I think that you realize that senators are also politicians, and you will see senators, they also know how to pray for the gallery, and they will ask questions, and you think that this decision is going one way. As a friend of mine would put it, we have just baked the duff, and we are waiting now to cook the chapati today. And I'm expecting to see a lot of fireworks, especially when the two defense witnesses come, including the accused. The Honorable Gachagua will also appear. And I'm expecting that mostly I have a problem with these lawyers because they love what is called a subjective argument to sustain their case. It is not more of an objective argument. So if you looked at the lawyer of the deputy president, he was actually subjective. I mean, the questions, rather than cross-examinations, were many in that whole argument. You were repeating 5, 6 times for the witness to actually reply to your question. And therefore, I think that Kenyans should not go and conclude that particular matter, because now, today is the day of the defense to come with their witnesses. And they will also fall the same, they will also face the same thing the Honorable Mutuse faced yesterday. And we are expecting that today there will be a different direction from what happened yesterday. And you know, when you are accused, you are the second person to present your case. And the lawyers for National Assembly, the lawyers for the Honorable Mutuse will get an opportunity to cross-examine the Deputy President. And that should be the highlight of the case today.
All right. So let's begin then with that one comment on social media that, and like everybody's saying, don't celebrate just yet from all the legal fireworks, all the legal brilliance that we saw yesterday. What do you make, Charles, of that comment that the Senate is not a house of integrity? And this is, you know, perhaps public perception coming in as a viewer's comment. What do you make of that statement with regard to your expectations of the Senate in delivering a fair and just trial for the DP?
I think the Senate represents what we are. We put those individuals in there, and they do our bidding to a large extent. And the Senate has done well, largely. Less, in my personal opinion, the small issue of the conflict of interest bill that is still pending out there, where they trashed, basically by way of amendment, the bill that had come from the National Assembly, and they wanted to do business with government. Even individuals who you thought were good individuals, basically were saying we want to amend this particular bill so that by the time it passes as law, we can be able to do business with government. Other than that, what they do is what they do. And remember, like Moshendo has said, my brother, these are politicians. They are politicians representing different interests, different regions, by extension, different constituencies that have different interests. So their priority number one work, in as far as I'm concerned, is to represent their respective regions. And that's why even when it comes to the counties, they are the representatives of the counties. So I have a feeling, ultimately, this will go the political direction.
Right.
Yeah, it doesn't matter what happens about the back and forth. And they know, it's because they know the DP has recourse elsewhere. Yeah. So much as we can see this, we are saying it's swaying this way, the other way, it will ultimately go the political direction. It is likely that quite a number of them will vote, not based on what is happening in court. Some have already voted, and you can tell. You can tell those that are supporting the Deputy President would have voted in a certain way, irrespective. There are others that would have voted the other way, irrespective. Then there is there is a number that is in between there that is waiting to be convinced by either side so that they can sway this or the other side. All right, but having said that, remember what we said about, and I think it's Council who said here, that in terms of the issue of how much you need to prove. If you remember BBI, which has been mentioned, BBI did not collapse because of the big things that were being said, the structure of our constitution, the basic structure. It collapsed because of two things. The fact that the president signed the bill, that one bit, that one signature. Number two, creation of the constituencies was okay in as far as the judges were concerned, judges of the Supreme Court. Those are the ones we are referring to. The problem was determining where those domiciling those constituencies, 5 in Nairobi, 2 in where, that particular bit, not the creation of the 70 constituencies that was very contentious across the country, and many people made a lot of noise. It was about Why are you domiciling constituencies? And that's not your work, that is the work of IEBC. So it's also good to look at this matter in that regard and see there are certain things in there. Out of 11 counts, there could pop up one, just one, that sways things either way. Either way.
So the threshold is pretty low, and with 11 counts, then really it could swing either way. But you speak of recourse elsewhere for the deputy president. We'll be speaking about that because as much as it is a political process at the end of the day, there's a lot of focus on having it follow the rule of law, having it be a fair and just process. And so, Areba, Senior Counsel Paul Mwite then raised several questions. And one that stood out was, again, on the process of a fair process for the legal deputy president, questioning why he is being accused of corruption and money laundering, but these crimes have not been reported to the Ethics and Anti-Corruption Commission. What are your thoughts on that point of objection by Paul Mwite? Does it hold any water? And could it offer a legal loophole for recourse for the deputy president after the process?
Let me first of all start with the issue of the Senate not being a house of integrity, and probably try to set a perspective in terms of where we come from, where we and where do we intend to go. After the promulgation of the current constitution, which is no longer new, but most of us still refer to new, there were people who thought that then the best way to govern this country is to vie for Senate, and others went for governor. Down the line, then there was a realization that for the senators, all they had was a big voice and no resources. That is why you saw there was a clamor for a number of people jumping ship from being senators and going back to vie for governors. Even as we speak today, my good teacher, Professor Tom Ojienda, Senior Counsel, sometimes says that most of the people in the Senate, they're there because they're just hanging around to go elsewhere, or they've come from elsewhere and they're hanging around just to be there. I mean, you know a number of governors who have vied back, a number of senators who are interested in governors. But then there was a resemblance of some kind of brains and common sense in the Senate, even in the level of debates. But then at the end of the day, even with this resemblance, I call it resemblance of brilliance and resemblance of some kind of logic, still ends in political interests coming. And that is where sometimes we have seen very brilliant debates, and you can see some level of objectivity. But when it comes to voting, you're like, oh, Jesus Christ, Mary and Joseph, where did we go wrong? Because then at the end of the day, the political inclinations and the political whipping takes place. So by and large, the Senate has tried, I'm using the word tried, to project itself as a house of reason and as a house of quality debate. But then what our viewers need to understand at the end of the day is that all these senators have a political tag on them. When it comes to voting at the end of the day, they still get whipped to their different political sides. So, I mean, it's an interesting conversation that has been online. I think I've been on nearly the entire part of the night. And people are saying, yeah, you know what, we can see some sense, but we hope they will be able to vote according to the way they're debating. Let me hold my coffee. When the voting comes today, you'll definitely know that Michelle belongs to the white party and my brother Charles belongs to the yellow party. Having said that, then we go to the kind of preliminary objections that we had yesterday. And I don't want to get to the academics bit of it, because then when you put a preliminary objection before the Senate, who's supposed to make a decision? Is it the senators or is it the speaker? So again, these are some of the issues that as students of law and students of politics, we need to get clarifications at the end of the day. Because when the speaker makes a ruling, is that a ruling of the Senate or is that a ruling of the senators? So again, as I said earlier on, some of these processes will better our political and our governance space. Because ideally, when you go to court and you make a preliminary objection, the court retreats, and maybe it might give you an opportunity to make your submissions, put in your documents, then the court retreats and delivers a ruling. When the Senate sits, my understanding is that it sits as a trial chamber, right? In that, if it was to be a committee, then it's not the committee chair who makes a decision. It's the entire committee that does what? That makes a decision. So my understanding, again, is that when the Senate sits as a whole house, it sits as a committee of the whole House. So again, this is a debate that has been raging between the legal circles, that at the end of the day, then who needs to make a decision? Coming to your question on how then do you adduce the evidence of money laundering before the Senate, which does not have original powers to do investigation on this?
Or even the National Assembly.
Even the National Assembly. And again, I'm pained to explain in terms of then how does the Senate do a conviction on that? And I get back to what Charles was saying, that when the impeachment was contemplated in Article, I think, from 149 to 150, the anticipation was that we were to set a level of recourse when it comes to quote-unquote bad behavior. When you talk about bad behavior, you don't necessarily talk about some of these crimes, because we have bodies which at the end of the day have powers in the Constitution to do investigations and make a decision. Because even if then the Senate was to make a decision that, you know what, His Excellency the Deputy President is guilty of money laundering, what will be the recourse? The Senate does not have a secondary power to do a recourse on terms of that. So that again goes back to the constitutional bodies like ESCC, the DCI, the Asset Recovery Agency, to be able again to initiate a process by themselves to be able to, at the end of the day, make a determination and apply the relevant laws to have recourse. So whereas to me, the preliminary objection seemed well-reasoned, but again, remember, this is largely a political process backed by the law. It's a political process backed by the law.
And so then it raises many, many questions. So let's come to you, Peter. That's a very good, good analysis, Areba. Picking from that, because the question was then, is this likely then to provide a legal loophole for the DP's team, DP's defense team, perhaps even during the judicial process that will follow after? And so as it stands then, we have that the DP team had requested that the National Assembly be disallowed to have the Ethics and Anti-Corruption Commission Chief Talib Mubarak appear to give evidence before the Senate because of that very concern that these allegations had not been submitted to ESCC before for ESCC to investigate and prosecute this matter. So why is it that then the ESCC boss is coming up as one of the witnesses? What are your expectations there, judging from the objection raised by Paul Mwite and really the explanation that Areba has broken down just now?
I think with tremendous respect to Senior Counsel Paul Mwite, who was once the representative of Kabete constituency, the larger Kabete constituency, I think mostly the defense team will most likely pray for the gallery, because as much as the Senate is a trial chamber, this is a political process. And when you look at Article 145 of the Constitution, which actually forms the basis on this motion, because you read that, I think 149, they are referring to 145 as the similar process to be used for the removal of the Deputy President, you realize that the threshold for members of Parliament and senators is very low. They do not need to go to any particular investigative bodies. A member of Parliament needs to raise enough reasonable doubt. Actually, the lawyers will tell you, in this case, the Honorable Mutuse needed to raise reasonable doubts for this case to proceed, because it's purely a political process, as we have said. And then again, when you look at ESCC and other bodies that are supposed to investigate, the creation of those acts is as a result of this Constitution. And unfortunately or unfortunately, the process of removing the Deputy President or the President is contained in the most supreme document of our country, which is the Constitution. And therefore, I think for me, as Aremba has said, that the politicians are expected to play their part. If the accused is not satisfied with how the processes of both the National Assembly and the Senate has conducted itself, he is free to move to court. And that is why you realize that the courts so far have exercised what these lawyers would call a judicial restraint. Over 20-something attempts to stop this impeachment have not succeeded in court, because at this point, the court will be seen as to meddle in a process which purely is political. So the court has said, look, this is a political process which involves both the houses of parliament. Please go through this process. And if the accused is not satisfied at how the two houses have held the whole issue, he can go back to court. And therefore, when you see the Honorable Paul Moita raising that issue, he's not likely raising it to actually convince the senators otherwise. He is raising it to put it on record that when he appears in a court of law, he will have been seen to have raised this issue. And I think for me that the drafters of the Constitution realized that both the president and the deputy president are a product of a political process, and therefore provided a process which is more or less political to remove them from office. And if you're not satisfied, you can now seek what you call the legal redress in the courts. So I do not think that members of parliament and the senators, there is anything wrong they are doing. They have no capacity to demand that you must have investigated the EACC, because the requirement by the Constitution or the threshold required by the mover of the motion does not require him to seek all those things the Honorable Moita is speaking about. He just needs to raise a reasonable doubt, convince his peers that I think this man is guilty. And then the Constitution has put a very serious threshold. For you to actually sustain those charges at the National Assembly level, you need 2/3. And I think for me that we want to be so academic about the whole thing, which I think for me, through National Assembly and the Senate, it is purely a political process. And these are politicians who are judging their own peers. It is like when Charles Munyui and Areba call each other learned lawyers. The president and the deputy president are being judged by their own peers who actually went to the ballot and they were given this responsibility by Wananchi. So I think for me it's a case of you being judged by your own peers through the same process that found you in those offices.
Right.
Michelle, just a clarification. There are two forms of proof. We have what we call the beyond reasonable doubt, and we have the balance of probabilities. Beyond reasonable doubt is usually applied mainly in criminal matters, in that if you say Michelle has stolen a pen, the evidence that you have to adduce has to be beyond any reasonable doubt that, one, there existed a pen, number two, the pen was stolen, number three, it was stolen by Michelle. Then the second one we say a balance of probabilities. Mainly it's civil. If you say Michelle owes Areba money, then you have to subject that evidence to a scale, and then you see on 51% where does it tilt to. It tilts to, yes, that one, the two are friends, two, they might have engaged in borrowing each other money, three, there's a possibility that Michelle might have given Areba money, four, Areba has not given that back money. So when we go back to what is going on right now, it is not supposed to be beyond reasonable doubt. It's supposed to be conviction of balance of probabilities. In that, if we take 50 plus 1, 51% on a scale of probabilities, there is reason to believe that His Excellency, Rigathi Gachagua, did this and this and this. And that is the threshold that is being used to do what? To crucify him in courts. So his accusers just need to convince on a balance of probabilities that, you know what, on the balance of probabilities, looking at the evidence that we have reduced, there is a likelihood that these offenses might have been committed. That is now the strict political process. The moment that is done, then because at the end of the day, all that will happen at the Senate, which will happen, I believe, today, is impeachment. Once it happens, then now the evidence will be subjected now to the relevant constitutional bodies to now strictly subject it to the beyond reasonable doubt, so that then there can be issues of criminal sanction. That's just the clarification I need to make.
Is it putting the cart before the horse, so to speak?
Not
leaving
really.
the legal process after the Senate trial?
Not really. Remember, as I've said, as two of my colleagues have alluded to, is that this is more like a peer political review. You know, there's peer review that even happens for you in your office. And your peers will look at you and say, you know, what we think is that Michelle is not performing very well. Let's sanction her.
I hope that's not a
I hope so too. So it's, as Mushelu has clearly put it is that these are your peers who are trying to give you your peer review. That, you know what, going by the provisions we have in the Constitution, we believe that you are not doing well. So now that we believe that you are not doing well, let's send you away. Because some of those charges, if you look at them, the way they are framed, they might not have any other recourse in the legal process. I mean, like the insubordination. You're not going to go to court and say, you know what, punish this guy because he's insubordinated his boss. But then when you look at these others like money laundering and all these others, if you look at the charge sheet largely, you realize that most of those charges are not charges that can proceed to a criminal trial for recourses. They're sanctioned in the political hygiene space, where at the end of the day you don't have any recourse. You cannot go to court and say, you know what, please punish him, he insubordinated his boss. Please punish him, he said this and this and this and this. There are just a couple of 1 or 2 or 3 which then can proceed to the criminal sanctions using the relevant bodies. So our viewers have to really understand that what Honorable Mutuse needs to convince the senators and the National Assembly needs to convince the Senate is that we believe 50+1%, His Excellency Rigathi, might have committed this. And on that basis is where the senators are going to vote. Right, so, I mean, just overall is that this is just a political hygiene process which on the large space of it, does not have recourse in the normal legal systems. At the end of the day, you and I will see this. What might be faulted from the courts or what might be clarified from the courts is the process.
Which will not have any implication, really, on the final outcome of the Senate.
I mean, it will have an implication in that, you know, if you had the ruling by the judges yesterday, they said, you know what, there is no harm in the Senate concluding this process, and then you guys will come back to us and we can issue appropriate remedies.
Okay, all right. So that's where the political process comes in, because if the seat then is no longer vacant by then, that's a whole other legal lacuna. But Charles, what are your thoughts on this conversation?
I think even before my colleagues came in, we had talked about that standard of proof, and it is as such. And it is also good to appreciate that even when it goes to the courts, it remains that way. It is not like the courts are going to up the threshold in terms of the standard of proof. They are going to look at what was the responsibility of the Senate in terms of proving these issues. Did it adhere to the standards as expected? It's not like we are going to be told, now that you are here in court, we need you to prove beyond reasonable doubt. We needed that to come out. They will look at what is the Senate charged with in terms of matters of this nature. So that is why you are seeing a lot of things happening. And like I said, there are 11 counts. 11 counts. You'll be surprised, like I said, about BBI. What will just pop up and sway this situation? And I'm talking about small things like nobody is talking about. For example, the issue of Nairobi County and the deputy president, the issues they are in. When counties, the national government and counties amongst themselves are supposed to behave in a certain way, and it's a constitutional requirement. It's not like it's a wish, you want to do this, you don't want to do it. It's about you. So you'll find, again, these are senators who represent counties, and this matter has come up. And those are the small things that you might not see right now, but they come out into play, and it shocks you to the extent that the average Kenyan out there wonders, I thought this was about stealing, this was about doing this was about owning this, belonging to who? Why are they focusing on the smaller picture? And we started actually by saying this country badly needs civic education. I think we need people to understand how these bodies work, how the institution of parliament works. You'll hear people out there, even very senior people in society, calling a woman rep, women rep. You know, basic small things like those that tells you there is a problem, because this is someone, even in media circles, calling that lady, that women rep, who represents women, you know, stuff like that. We need civic education so that Kenyans can understand how do these processes work. Now that we are stuck with these processes, what does it look like when this matter has gone to court? The courts have sort of like, in the minds of the average Kenyan, lowered the threshold. Why are they, wanaonea huyu kwa nini? Why are they behaving in a certain way? And that is what is going to be at play. A lot will be said. It can be messy, obviously, when you're in a matter of in court, because the Senate, as we speak, is a court. A lot will come out, but ultimately the decisions will be around the 11 issues. which are crushed, consolidated into three aspects, like we said, of gross violation of the Constitution, gross misconduct, and committing a crime within the threshold as provided. I think if people can understand that, then it will become easier for them to see how the end result looks like. And remember, like we always keep repeating, this is a political process largely. Yeah, if you look at it as a legal process, then you lose the point. It's a political process, and ultimately it will boil down to how many senators vote for or against the motion as it is.
Right, and that will happen.
The counts,
that
not
will
the
happen
motion.
later this evening. And so then sticking with the fact that this is largely a political process, Areba says again, historically, it's a learning moment and a learning process for the country. And I believe also, outside of legal minds, those also learning are those who have political ambitions to even hold the seat of the deputy president. I mean, this seems to, the whole position seems to be a revolving door of political casualties, you know, with every administration. There's always someone left out in the cold, exit points always changing, seemingly. And so what we saw play out on the floor of the Senate yesterday was, you know, the prosecution laying their case on how the deputy president had been insubordinate. You know, he's talking about shareholding and all these things. And then we have the defense coming out and showing the president saying the same things, really, in a different context that the deputy president had been saying. And so here is the deputy president asking, this is what he did. I learned from my boss. So what did I do wrong? And so specifically, there was the issue of shareholding. And we had a clip of the president, William Ruto, speaking about shareholding in this administration. And so there's been many questions then as to really what the next deputy president should or shouldn't do, what they should be learning, should they be doing what the president is doing. So Areba, what are your thoughts on, you know, just that line of defense by the DPS team? Like, you know, the president did it too. Why is it such a big deal?
Before I come to that, Michelle, there's something very critical that you have raised, and I want to draw it back to the deputy governors. Some of us have been on the rallying call and saying, you know what, we probably need to look at our laws and know what the distinction between a governor and the deputy governor, and probably have a recommendation that, you know what, a deputy governor should be a substantive office holder, probably a CEC or something of the sort. Why is that? There's some counties that if I ask you who's the deputy governor, you will not tell me. I can tell you that for sure. 10, 15 or 20 of them, I ask you who's the deputy governor, you will not tell me. Remember, we had, even in the last dispensation, we had a number of issues between deputy governors and governors. And even right now, Kisii already, the deputy governor has gone down. We have a new deputy governor. The deputy governor was impeached. And there are some counties where basically some deputy governors operate even from Nairobi, and the county is probably in Nyanza. Or some of them, I'm told, the deputy governors live abroad, and yet the county is going on, which clearly shows there's some kind of, there was no clear thought process in terms of the framers of the laws, the Constitution and the County Government Act, in terms of functionality bit of it. I think some people are too quick to apportion positions without looking at the functionality bit of it. Again, as I say, there is no perfect law. Each law, once it's subjected to its implementation, then you get to realize the gaps and probably put in a review mechanism. So borrowing from that, and we copy-paste the same to the national scene, and we go back to President Uhuru Kenyatta and Deputy President William Ruto, as then he was, and you could see the conversation around that probably sometimes His Excellency the President, as then the Deputy President, could say that, you know what, he had nothing much to do. There were no specific roles that were apportioned to him. Even the constitutional ones, like the IBEC, they were dysfunctional. We got to the 2022 elections, and once the duo of President William Ruto and His Excellency Rigathi Gachagua are sworn in, specific tasks are assigned to His Excellency Rigathi Gachagua out of, let me say, how can I say it, gentleman's agreement, or out of good manners, because I think the only one which is provided by the law is the IBEC functionality. And then the Deputy President is handed over the issue of tea, coffee reforms, which again I can say was out of good manners, I'm using that word sparingly. And he also takes over the issue of alcohol, which again became a time bomb down the line. And a number of us are now questioning that going forward, and in terms of our legal reforms and our political space, how then do we get to align the two so that away from the deputy president being the principal assistant and the deputy governor being the principal assistant to the governor, how then in terms of functionality are we going to ensure that Kenyans get the best from these two positions? Again, I want to jump back to the deputy governor because this is a bit tricky for me to discuss. For the deputy governor, I know of counties where the governor would call a CC and tell him, you know what, guy, go and represent me on this and this function. I'm not available, please chair this committee. And the deputy governor will do nothing. I know of a county where the deputy governor lives in Nairobi and the county is 400 kilometers away. And the last time the deputy governor was at the county headquarters was close to 6 months ago. And whenever he's back there, he just reads his newspaper and goes back home. He has nothing to do but continues to draw a salary, uses the taxpayers' fuel and personnel. Which then, coming to your question, which then points to the need to legally define the roles of some of these positions. Where I think there was, in the issue you have raised, you realize that then at that point there was no defense. It was just playing to the public gallery. In that, you know what, because His Excellency the President, William Samoei Ruto, was not on trial. I mean, you don't say, you know what, you stole this jacket. Then you say, you know what, Mushendu also stole 2 jackets. Why are you not calling Mushendu here? You're saying, you know what, it's about shareholders. You say, you know, the president also said these are shareholding. And they failed to get the logic that, you know what, the person on trial was the person of His Excellency Rigathi Gachagua, not William Samoei Ruto. And that, to me, as Mushendu said, was not a defense meant to sway the senators. It was just a defense meant to portray the president in bad light that, you know what, how comes that when you say this, there is no repercussions? But when your deputy says this, there is repercussions. So it was a play to the gallery, and because even that evidence at the end of the day cannot be sustained elsewhere, that, you know what, I stole because Michelle steals every day. Or rather, I said this because this one said this. I said this because this one said. So again, it's a slippery road when it comes to management of affairs between, again, I'll use the governor and his principal assistant, who is the deputy governor, which is now replicated to the president and the deputy president. I don't want to get into specifics of the shareholding and all that because, again, we want to hear more about it today, so I don't want to preempt this. We can have this discussion later. But absolutely. I felt that was a wrong trajectory in saying, you know what, I'm learning from my boss. This is what my boss said, and this is what I said. So it was a bit, for me, it was off.
All right. Mushendu, what are your thoughts on that, especially because you made it very clear that, you know, they're not playing to the gallery, really to sway the, really to sway the Senate, but more for public emotion. Yes. And because we keep saying this is a political process, perception in politics really is key. You know, public perception shapes a lot of things. And so, playing to the emotions of the public and of the electorate in the manner that we've seen the DP's defense team do, what implication is that likely to have politically for the Kenya Kwanza administration, especially should the Senate uphold this impeachment?
Well, I want to believe that this being a political process, every political process has winners and it has casualties. And I can tell you, there are, yes, members of parliament that will, in the next 2 years, also face the wrath of the public who believes they did not make the right decision. But you realize that it could be a painful process for the president himself. When you work with a deputy president who is willing to talk about NIS in public, for instance, he sits in the National Security Committee, where he is the right place to prosecute the issues of NIS. And as a president, you feel that, because look at the Constitution and the laws of the land, who appoints the Director of National Intelligence Service? It is the president. That particular nomination is subjected to grilling in Parliament, and subsequently, when the Parliament approves, the president appoints. But you have a deputy president who is willing to critique the appointment of the president in public, which for me is not the right trajectory to take. you have a president who is willing to go to the public, and rather than discussing the merits of the cabinet memo which sought to clear out those people who have engraved the Nairobi River, you pray for the gallery and you pray what is called personal preservation politics, that you want to exclude yourself from a decision taken by a cabinet meeting which you sat in. And therefore, I think that when you look at the politics of the day, the idea for the deputy president, it is to drum up emotions. But the question for me is, how long would you sustain those emotions? Because, of course, emotions are emotions. Their adrenaline rises up and goes down based on how long you take it. Because in our language, where I come from, we normally say, once the crown leaves the head and it is on the floor, it is nothing more than just a metal. And that is the plain truth in the political world, that is the deputy president able to sustain the politics of the day of whipping emotions for the next 2.5 years? Because from what I suspect, because this is a political process and even senators are politicians, from what I suspect, because I do not sit in that August house, but you have your ears hearing what people are saying, there is a very big possibility that his peers are going to impeach him. And today, at the end of the vote, it is the most unfortunate framing of our constitution. It says, as long as the Senate votes to support the motion, automatically the deputy president stands impeached. And the most unfortunate thing in the Republic of Kenya, it is that the threshold of you making the next president in 2027, it is so high that you need 50+1, you need at least 25% from the majority counties. And I feel for the deputy president, because he has perfected the art of every time there is a storm in Nairobi, he does not go to the west, he does not go to the south or the north, he always makes a trip to the east. And unfortunately, the east in its own cannot be able to make you become part of the 2027. We also have the ruling that says that if you are impeached, you cannot be able to participate in an electioneering process. And therefore, looking at it from the political side of it, they are doing a good job in whipping people's emotion. But for you to succeed that route politically, the key thing here is sustainability, which I do not believe that the deputy president has the capacity or the means to sustain raising the emotions. And in this case, he's only being successful in raising the emotions of a fraction of the mountain, which is rather unfortunate.
Let's take a break on that note. Some may say that the task facing the DP may be higher than the mountain that he's been talking about. So let's take a break on that note.
I thought Mushalu would say where he comes from, they say Bora Usiguza Mulima.
Let's take a break on NTV. We'll be coming back with much more of that discussion, as Gachagua will be deemed to have been removed from office should 45 out of 67 senators vote to uphold any of the 11 charges that have been leveled against him. The Senate will convene at 9 a.m. this morning to continue with that make or break ouster trial against the deputy president. Do stay with us as we give you wall-to-wall coverage of that, as well as your comments, thoughts and questions on our social media channels at NTV Kenya. We'll be sampling them after this break. Do stay with us.
Regarding Gachagua, hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu.
Kenyans will be shocked.
Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures in support of this motion.
Try the new Dunked All-Star Box for only 8.90 Kenyan shillings. Hope you're ready for the new star of the show. KFC, it's finger-licking good while stocks last.
Get ready to tantalize your taste buds and embark on a culinary journey with Pishi Bomba, the ultimate cooking show that brings the flavors of the world right into your living room. Tune in this Sunday at 6:30 p.m. with me, Claire Karatu, for a mouth-watering adventure. Pishi Bomba. Cook, eat, enjoy.
Even though I never really became your legitimate daughter-in-law, but you've been every bit of a mother to me.
What's that? I thought our celebration's over.
Not quite yet.
Oh.
Happy birthday, Mom!
Adele! I thought you said you couldn't make it.
Where did you come from?
Come with me. So this is where the magic happens. This is for you kids.
Taste the magic with our festive cakes from DPL Festive Bakery. Delight with every bite.
Are you ready?
Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu.
Kenyans will be shocked.
Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures in support of this motion.
Welcome back. This wall-to-wall coverage of this historic impeachment trial against Deputy President Rigathi Gachagua on the second day of the Senate ouster motion. It is the turn this morning of the Deputy President to take the stand and defend himself against all the 11 allegations that have been leveled, or 11 charges rather, that have been leveled against him. The country expects that in the submissions, Gachagua will present evidence, affidavits, as well as witnesses, during which his team only has one to testify, and so it will be an exciting contest really for the country to watch. 1 hour from 9 a.m., however, will be dedicated to cross-examination and re-examination of witnesses, as senators are given an hour to ask questions or request for clarifications, and we'll be giving you that wall-to-wall coverage here on NTV. And in studio with us, we have a panel of guests to put it all into context as the legal jargon continues. We have governance analyst Charles Munyui, political analyst Peter Mushendu, as well as lawyer Reba Samba. Gentlemen, many thanks for staying on with us. And so even as, we talk about the expectations of the Deputy President's defense this morning, because we've seen him do this the day before he showed up, the day before the National Assembly made or passed the impeachment motion in a live televised address. What will be different this time? But I'd like to come to begin with you, Munyui, on the issue of the political futures, not just of the deputy president, which really now hangs in the balance. What does this entire impeachment trial mean for the political futures of the likes of the mover, for example, Mwengi Mutuse? Because initially it was a big contest as to who will actually bring the motion to the table. Yes. So what's at play on the political side?
Before I get there, let me talk about something my brother talked about here in terms of that particular position of deputy president and by extension deputy governors. As we speak today, and I think he alluded to it, there is an amendment bill, County Governments Laws Amendment Bill 2024 before the Senate, and is being pushed by deputy governors. And inter alia, they're asking, among other things, can you imagine, they want it in law that the notice for CEC meetings, County Executive Committee meetings, which is the equivalent of cabinet meetings in the counties, they should be given sufficient notice and it should be provided in law. Can you imagine how bad it is that you have a deputy governor who does not know when there is a cabinet meeting, yet he's a member of the cabinet? Yeah. So I think much as we are talking at the level of the deputy president and what he has to do, there has been a lot of benevolence, if you ask me, on the part of the presidents, whether it's Uhuru or the President William Ruto, in terms of the functions they have delegated or given to their respective deputy presidents to operate, and especially the current deputy president. There are clear functions. If you go to other counties like Kiambu, Mushendo will tell you, we had deputy governors who also used to walk into their offices, they get out and they find their vehicles have no wheels. And you ask what happened, you are told, no, we realized the wheels had a problem, so we have removed all of the 4 of them, they are being worked on. So you look for, you find your office flooded, someone has just put water in there, yes. You cannot work from there. So there's a lot going on in terms of that particular office, but I'm of the opinion that we cannot have 2 centers of power. It will be unfortunate if we start having in law that the deputy president must do this. If anything, the reasons as to why you're finding some of these differences is because all of them are politicians, they have ambition, and you have started a process of growing yourself politically to the extent that you might be the biggest challenger for the person that you're working with as your boss. So I think that would be a little tricky. And that's why this I would have a problem if we started now putting into law that the deputy president must be this, that must be that. If you want to be president, just go for the presidency. Don't go and get accommodated as a deputy president. If you want to be governor, go for the seat of governor. Don't go seek the position of deputy governor and then put terms and conditions, unless you are coming with a party, in which case, and a lot of other MCAs, as it were, then you can have a conversation around what do I need to do. Having said that, in terms of the futures of the respective individuals in this at play, number one, it is important for parliamentarians especially to know, to appreciate that now they are being more scrutinized more than they have ever been scrutinized by the general public out there. And you've had it happen. You have had people saying, you guys behave badly, yet you are the judges of the deputy president. You want to judge the president, and you have done far worse criminal acts that some are alive before court, others just somehow, slid. We allowed it to slide. But we know you've done a lot of things out there. You behave badly in the public, yet you are the ones who sit in these seats when it comes to judging who is done what, whether it's the deputy governor or whether it's the governor. I think politicians now, especially members of parliament, both houses, need to appreciate that they have a role to play when it comes to oversighting government. And you cannot be the oversighter, yet you are the ones who has a problem in the first instance. And I'm saying so because we have seen a lot of issues. Our members of parliament, especially National Assembly, have become individuals who walk around with bursary forms as their work. That is the only thing they know what to do. They are the ones that will walk around there and brand every government project in their names as patron this, patron the other one, even when it's not provided for in law. They are the ones who will do all these things. Then they want to be the ones that we are looking up to resolve issues of serious national importance when that time comes. So I think moving forward, our leaders, whom we respect a lot, must style up and appreciate that the pedestal is slightly higher now, the expectations of their part is slightly higher. As for the deputy president, I have this strong feeling that the relationship between the two of them and the president has crossed what we call the Rubicon. I don't see how they can work together. I simply don't see how they can be put back together by the Senate. They can be put back together by our courts. But I don't know how that will work when a lot has been said out here, unless, I don't know, they go for counseling and they have sit together. They go for retreat, just the two of them. They even go for holiday. I don't see how that happens. A lot has been said. We have come to know, much as the president has not said it on national television. But I think this relationship has crossed the Rubicon, and what we are expected to see, assuming they're back together, is one person going this way, seeking elective position in 2027. Naturally, there is no way he's going to be the running mate to the president in 2027. So it will still split. The roads will still be split for both of them. Yeah, and it's not clear at what point they will start, like having a meeting point.
All right. We've mentioned legal recourse several times, really, and even perhaps political recourse, if there is any, for the deputy president, because as we wait to see how the Senate vote will unfold, the larger prediction going by voting patterns in the National Assembly is that the Senate is likely to uphold this impeachment. There's already conversation on what happens, the road to replacing the deputy president. We've had a lot of political banter that perhaps a lot could be happening already as we speak in the race to replace the deputy president. Areba, is there any recourse at any point for the deputy president? And many say then this recourse has to be before this seat, should it be declared vacant, before it's filled by somebody else.
So just for the record, is that once the Senate votes today, and the moment the declaration is made by the speaker or the clerk or whoever does it, then there's no need to do gazettement or to do all those other processes. The seat falls vacant immediately, and His Excellency Rigathi Gachagua immediately ceases to be the deputy president. Now, one of the things I want to inform our viewers and everybody around is that sometimes judicial restraint and some kind of politics of the judiciary come into play in such matters. Why am I saying so? The judiciary would have gauged the general mood of the movement of this motion, and that informs the final decision that it makes. Let me put this into context, Michelle. Today, if I don't want to use you, let me use myself. Today, if my boss fires me and says, you know what, I don't want to work with you, I go to court and come with an order and say, you know what, court has decided that you have to take me back. Liwe liwalo. Same case with maybe our domestic managers, or maybe if you have a driver, or even a spouse. The court will be very awkward to tell you, you know what, you don't want this person, but please stay with them. I have given you an order that you have to be with them. Then that relationship becomes more and more frosty. The context is the secretary to the cabinet has sworn an affidavit against her boss, who's the deputy president. And that affidavit, probably you and I will say, has been sanctioned from, there's no way the secretary of the cabinet will swear an affidavit against the deputy president if there are no sanctions, or rather there is no support from other quarters. Let me give it into context again. What if the court comes out and says, you know what, deputy president, please go back to office? Then how is he able to work with other quarters in government when there are such implications? Which cabinet will you be able to attend when even some CSs, you've seen it, some CSs have come out, even during public participation, right. We had a couple of CSs out there championing the public participation. Then which cabinet will you be able to attend? So, that also informs the judiciary at the end of the day in making its determination. Right. Parliament already voted 85% to impeach, rather to pass the motion to impeach the deputy president. If then yesterday, sorry, the three-judge bench will have said, you know what, stop, deputy president, go back to work, give us some time to listen to the case and make a determination. It will present a very awkward situation, even in terms of governance, where you have some junior officers have talked against, are in support of this motion in their personal capacity or in their official capacity. A number of quarters from counties, a couple of governors have said, you know what, you need to go. Even, you see, even the lead counsel for the National Assembly is a governor. Then how will that IBEC meeting be? So some of these considerations was what the judiciary is putting into mind and say, you know what? Whereas at the end of the day, we can provide guidance in terms of how ABC is supposed to be done. From where we sit, it seems that this relationship cannot be held together. This is more like trying to get two aeroplane parts and putting them with sellotape, and you're trying to fly this plane. It is catastrophic. And that is why the judiciary, again, judges are not aliens. Judges are our brothers. They are our sisters. We live with them in this society. Some of them are watching us. And they keep on seeing what happens every day. And that plays a key role in the decisions they are making. To conclude, what I anticipate the courts will say is that they might, again, it's a might, they might fault some bit and pieces of this impeachment process. But then again, they cannot go and say, you know what, the impeachment was wrong, because it will have been overtaken by events. If you had the three-judge bench yesterday, again, they said, when it comes to the public interest, from where we sit, we feel the public interest is allowing the constitutional process to do what? To proceed to its logical conclusion. And then if you are faulting that, come back, we will be able to issue appropriate remedies. I mean, at that level, the only remedy that will come is to probably do guidance in terms of how future processes are supposed to happen. But there is no way the court is going to say, you know what, you were impeached wrongly, please go back to office. And by then you'll be having another deputy president.
All right. So then that being said, Mshendo, why politically do you think, because with public perception, it is clear then that even the deputy president would anticipate the outcome in the Senate. Why do you think he chose to go through with the impeachment trial and not resign, as many had been asking him to do?
I think, as I said, that the idea is to play with the emotions of people. If you resign, you actually indirectly admitting that you are as guilty as charged. And therefore, he does not want to portray the image of someone who is looking guilty, and therefore he does not want to resign, because resignation would mean exactly that. Number two, he is hoping, you can see the excitement that was there last night as his lawyers cross-examined the mover of the motion. He is hoping to rain on those emotions of people who are watching this live on TV, that he would look like he is as white as snow as his lawyers cross-examine the movers of the motion. And therefore, I think one of the major problems that we face in this country, and we must look on a way to resolve it, it is the moment we want to exploit our communities to have what you call personal gains. That my community is only good when I am pressed and I can use it as a shield. And I think basically that is one of the major problems that His Excellency the Deputy may need to look. The other issue is, and I think this is one of his major undoing, was that the personal experiences of members of parliament with the DP have not been as present. I have been able to witness one or two altercations when the deputy president is openly in public lynching members of parliament from Mount Kenya. And therefore, the moment you come to face your peers who believes that you have no respect for them. You would remember the night before he appeared in the National Assembly, he referred to the National Assembly in not so good words. And therefore, you have already created that anticipation of people wanting to look, waiting for this man who does not respect the National Assembly to appear before. And therefore, the Deputy President is hoping that if he can be able to, and that is why he has accepted to actually come as a witness personally today, that he is able to, again, he is not here to convince the Senate that you need to hear my case. He is here to do what I would call a political grandstanding. You are not speaking actually to the Senate. You are speaking in the Senate for those who are following the proceedings to hear what you have to say. It is the same thing we saw him do in the National Assembly. He was not really speaking to the National Assembly members. He was actually speaking to those who are following the proceedings. And I think that is the reason why he has chosen not to resign. And I think, as Areba has put it, is that the drafters of our constitution did not envision two centers of power when they put these positions, that of a deputy president and that of a deputy governor. In fact, there is only one reason that allowed them to put this position. They looked at a vacuum that would come. Actually, the only responsibility of a deputy governor or a deputy president, in accordance with our constitution, it is to ensure that whenever the president is incapacitated in whatever way, there do not exist a vacuum of power. And that is basically the same, because you realize that the president has been too generous to the deputy president. If you look at the content of Executive Order number 2, where the president has transferred quite a number of functions to the deputy president. Today, if you insist you must be there and probably the court upholds that you must be retained as the deputy president, and all these functions which were given to you as a courtesy by the president are taken away, how then are you going to be helpful to this government? You know, a political relationship is not like a marriage where if you want to file for divorce, you are told first of all to file for separation to see whether you can reconcile. A political union, when it is done, it is done. And as Munyui has said, it seems this political union of the deputy president and the president has gone beyond what I will call a repair period. You know, in Kenya we say that, if a vehicle is 10 years, has been 10 years old, you cannot import it in Kenya because it does not meet the standard. In this case, the relationship between Geoffrey Rigathi Gachagua and one William Samoei Ruto seems to have gone beyond a point of no return. And I would, if I was the deputy president, I'll do the honorable thing, and I will save my political future. I will resign, and I'll give reasons and say, I don't want to be a part of government that does not want to work with me, if I was Rigathi Gachagua. But unfortunately, because the idea is to whip the emotions of the people, he cannot resign. And that is the reason why he has prolonged this issue, despite him knowing.
And the ship has sailed, really.
You know, the way all of us are thinking that Senate is going to impeach him, it does not mean that he does not know that too. He also knows that too. But he is using the benefit of the time given on national TV to execute what he wants to execute in the eyes of the public.
Absolutely. You know, as it stands, there's been a lot of conversation as to his replacement. And legal experts say that the law gives the president and parliament absolute powers to fast-track the replacement process, excluding the IEBC and even excluding the requirement for public participation. And so even unlike the nomination of CSs and other state officers who require vetting, this will really be a decision of the president and Parliament. There's been talk that Parliament may be sitting as early as tomorrow to debate on this issue. But Munyui, we've seen the deputy president proudly say that he is a man elected by more than 7.2 million people. So he is not going to resign. He's going to fight till the end. Now, during the trial yesterday, we had a lot of submissions on the issue of shareholding. And the defense broke it down, you know, while giving their defense on what the agreement was within the Kenya Kwanza alliance itself, and that the different affiliate parties within Kenya Kwanza were awarded benefits, you know, that were commensurate with how many votes they brought in. And so you were mandated to bring 30% of the vote, and you will get 30% of these. And so essentially, they say this is where the basis of the word shareholding that the deputy president spoke about came from. And if you hold shares, then essentially you are a shareholder. Now, with this imminent impeachment of the deputy president, and the president, of course, choosing his deputy next, there's many talks, even during the public participation, that the Kenya Kwanza government may just be impeaching itself by impeaching the deputy president. Where does that leave, then, the issue of the shareholding, the 7.2 million people that perhaps still support the deputy president in his view, and how the president is likely to play it to retain the support of the mountain. That seems to be crucial in the numbers.
I think it's interesting. It is interesting, and I need to appreciate, to understand. Fine. One of the serious most charges against the deputy president is that he works only for the Mount Kenya region. He is keen on the Mount Kenya region benefiting from government at the detriment of other regions. Yet, just about all Mount Kenya members of the National Assembly voted to have him go home. I think that's a conversation we need to have. So I think the conversation is slightly bigger than issues of the mountain, because I come from there. Even my own MP, Member of Parliament, personally, much as the public participation on the ground was saying, don't vote yes, vote no. He voted yes, he voted for. I think the relationship between Deputy President Gachagua and the members of Parliament, both houses, has not been very good. It has not been rosy at all. And if you remember, even when he was being picked as a running mate to the president, way back, and at some point, the president had members of Parliament from the region help him determine between Professor Kindiki and Rigathi Gachagua, whom do I pick? Members of Parliament, big majority of them voted for Professor Kindiki. So from the onset, they did not have a good relationship. And then I believe he never built on that relationship to the extent that even a lot of these things that are happening now, it is because he has issues with those particular members of Parliament from the region. Having said that, I agree. The issue of the shareholding and the issue of this and that, again, we have laws that don't make sense, if you ask me, in this country. We cannot have a constitution that says, oh, Kenyans are equal before the law, this is your government, this is what is happening. Then we allow ourselves, through a provision in the Political Parties Act, to literally decide who gets what and how many numbers we have. And I think that's something that needs to be redressed. And I have a feeling right now as you speak, there will be people going to court and saying these particular provisions of the Political Parties Act are unconstitutional. Because if you are guided by what you agree, and you remember this is a country where people are mobilized around tribes. In fact, the current president really tried to move away from that. He really tried to move away from gatekeepers, because he realized that will not work for him. If you remember, he talked about hustlers versus these other fellows that have been messing with you. Then he went with that discussion and ultimately said, I have a solution called bottom-up, and this is how we'll. He never mobilized to a large extent around the tribes. And it's only fair to say that when they were looking for votes, even in Mount Kenya region, a majority, those people are voting for President William Ruto. They were not voting for anybody else. And they said, even when people are saying, huyu anakuanga anafanya hivi anaibanga, they said, huyo ni mwizi wetu. That's a conversation we need to have, so that we ask ourselves, this shareholding, how can we resolve it permanently so that even people don't find, even political parties don't talk about it?
All right, I'll just take a break. We'll come back with much more on this debate. We will be back with this. That is governance analyst Charles Munyu. We also have political analyst Peter Mishendo, as well as lawyer Areba Samba. We take a short break and make time for Your World with Winnie Lubembe. We'll be back at 9 a.m. as we give you more analysis on that make or break Senate ouster trial against Deputy President Rigathi Gachagua. Many thanks for watching us this morning. My name is Michelle Ngele Odhiambo. Do stay tuned to NTV.
Rigathi Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu.
Kenyans will be shocked.
Hiyo ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures in support of this motion.